Good morning, everyone, and welcome to Burden LLP and Alston & Bird joint webinar. I'm Gladiola Lohia, a member of the marketing department here at Burden, and I'll be making some brief introductions and announcements before the program begins. Today's webinar, Inbound USA Tax and Legal Requirements and Avoiding the Unexpected, will be presented by Richard Goldstein, our Senior Tax Principal and co-leader of Burden's State and Local Tax Group, followed by Richard Slowinski, a partner at Alston & Bird's Federal and International Tax Group, as well as Zach Gladney, a partner at Alston & Bird's State and Local Tax Group. Good morning, gentlemen.
Morning.
Good morning.
Today's presentation will be approximately 60 minutes. At the end of the presentation, our presenters will be happy to answer as many questions as time permits. Please feel free to send your questions throughout the presentation by using the Q&A feature at the bottom of your screen. This program will be recorded and you will be receiving an email with a link to the recording in the next few days. With that being said, I'll pass it off to Richard Goldstein to kick off the presentation. Richard?
Good morning, everyone. Thank you, Gladiola. Thank you, everyone, for coming today. We have a pretty extensive agenda. I've got 20 minutes to go through some sales and use and income tax nexus issues. Today, what we're going to do is we're going to start with sales and use tax. We're going to discuss one of the key cases that came out in 2018 and how that will affect clients who are coming into the United States to do business here, or for that matter, clients who are already here and doing business here on a multi-state basis. Then we'll take a look at income tax nexus for businesses, and there are four major issues there: physical presence, economic nexus, factor presence, and the Interstate Commerce Act of 1959. So we'll discuss all those things in detail. So very briefly, the two main issues we have in the United States regulating interstate commerce is the Commerce Clause, and then the Due Process Clause. Also, it was relevant to multi-state taxation. You can see there's a lot of other clauses, generally not a huge issue for state and local tax. Okay, so basically, Congress has the power to regulate commerce amongst the states. And the key issue there on the Commerce Clause is that it doesn't, whatever state is tax is imposed, it doesn't create an undue burden on the interstate commerce. In other words, it doesn't basically interfere with interstate commerce and reduce it to a point where it's inefficient. And the second clause we discussed is due process. And basically, the idea is that there has to be some connection between, what the business is doing, what the state is offering in exchange for that, and whether the business should be aware that that their business within the state will give rise to taxation. So, doing business in state and nexus. The concept of nexus and doing business are interrelated. Doing business generally means that you're engaged in some activity for gain or profit, and sometimes being organized or commercially domiciled within a state may be considered doing business in state. Let me pause here real quick just to say that the idea here is that people or businesses should be aware that when they organize in a state or become commercially domiciled, they may become subject to tax in that state. Okay, Commerce Clause. So, so basically, as we said, the Commerce Clause applies to interstate commerce, and there needs to be a substantial connection, which essentially means nexus to the state, in order for the state to be able to impose taxes. There are other issues related to whether or not a tax is good from a multi-state perspective, whether or not the income is fairly apportioned to the state. In other words, is the state taking too much income from a multi-state business? Does the state's laws discriminate against interstate commerce. In other words, favor in-state commerce over multi-state commerce. And does the services that the state provides to the business, are they fair in terms of what they're asking from the business? So like, having good roads that you can drive your trucks on, having a police department, having good fire safety and all that sort of stuff. Due process is has a much less stringent requirement in terms of the contact. It just requires minimal contact, doesn't require any physical presence. Now, for sales and use tax nexus, used to require physical presence. A business had to have some sort of physical presence in the state in order for the state to require that the business register with the state to collect and remit sales tax to the state on taxable transactions. And that was upheld in Quill versus North Dakota, which is a 1992 Supreme Court case. In that case, we had the old mode of doing business where a product supply company, a business office supply company, would take orders over the phone or through a catalog for a local business. Maybe they were sending paper, maybe they were sending pens, whatever business supplies, but they had no location. Quill had no location in North Dakota, and North Dakota tried to say that you need to be collecting sales tax or pay use tax if you didn't collect the sales tax, and the Supreme Court disagreed. They said no, you need to have physical presence. Well, all that changed in 2018. In June of 2018. A case some of you may be familiar with, South Dakota versus Wayfair Inc. Wayfair Inc. It was actually challenging a South Dakota statute that said if you have more than $100,000 in goods sold to customers in our state in South Dakota, or services, or you have 200 or more separate transactions or goods delivered in or services in the state, then you were required to register with the state, South Dakota, and collect sales tax on transactions from your customers. And basically what Wayfair was saying is that, look, Quill said we have to have physical presence. We don't have any of that. People go online, they order our stuff, it gets shipped in state to them, it gets shipped to South Dakota from out of state, and it gets dropped off, but we don't have any warehouses. So we don't have any offices, we don't have any people employed in the state. So why should we have to comply with this? The Supreme Court basically overruled its decision in Quill and said, you know what? The South Dakota law is fair, and you do not need to have a physical presence. The South Dakota law is based on what we call economic nexus. It's based on the amount of business you're doing and how you're benefiting. And that was back in June of 2018. Ever since then, practically every state that imposes a sales tax has imposed some form of this, which has meant that lots of businesses are getting caught up in a situation where they now have to collect sales tax. They have to register, they have to file tax returns, they have to collect resale certificates to document exempt sales. They have to do all these things that they never had to do before. And if they don't do it, the consequences are severe. Not doing it basically means that you could end up in a situation, a business could end up in a situation where the sales tax that they do not collect from their customers is now their sales tax. In other words, it's become their cost of doing business, which obviously is a horrific situation. So you would never want that to happen. So let's go to the next slide. As I said, the overwhelming majority of states have adopted some sort of Wayfair type economic nexus. The key, devil's in the detail. There's so many different varieties of this. And so you need to be aware if you're going to be selling to customers in states, what kind of statute they have. Like, for example, Illinois says 100,000 in sales or 200 transactions. It's an or test. but they exclude retail sales for resale. In other words, they exclude wholesale sales from this threshold. New York, on the other hand, says you need $500,000 in sales and 100 transactions. It's an and, not an or. And the threshold is based on the sale of tangible personal property, not services. Unlike other states, you'll look at Texas, and Texas says they just look at total revenue. They don't even have a transactions test. And so you can see how, and it's based on tangible personal property and services. New York's only tangible personal property. So there's other varieties as well. So again, understanding whether or not your business has an obligation to register for sales tax is a big deal. Basically, this type of nexus, we call that economic nexus, Wayfair nexus, what we just discussed, applies pretty much to everybody, whether you're a retailer, a wholesaler, a manufacturer, not-for-profit. Those standards apply to everybody. So there's other standards that continue to apply. So if you have physical presence in a state, if you have an office or warehouse employees, you have to register for sales tax too. That didn't go away. There's other types of nexus called click-through nexus and affiliate nexus. Affiliate is pretty interesting. It's like a situation where, let's say you have Macy's, which has a brick and mortar store in your state, but they also have Macy's.com. Are the stores integrated with the out-of-state online business? For example, you can take items you bought online and go to the brick and mortar store and return it at the brick and mortar store, even though you didn't buy it from the brick and mortar store. A situation like that could be considered an affiliate nexus. So even though you're an online company, you may need to register and collect sales tax in that state. Another big thing that's happened is marketplace facilitator rules. They're basically use the same standards that we just discussed on the economic side. In other words, number of transactions and or number of amount of sales. And basically, marketplace facilitator, classic example might be somebody like Amazon.com. If you become a marketplace facilitator, even though you're selling other people's goods, if you exceed certain thresholds, you now are the retailer. You now are the one who has to collect sales tax. And so that's something to be mindful of. The rules are all over the place. Many, many, many states have enacted this. The key points I think I've already mentioned, but the basic idea is that marketplace facilitators become the retailer. They have to collect sales tax. They have to register. They have to collect exempt certificates, etc. State income tax nexus, the classic nexus there. So now we've moved from sales tax to income taxes for businesses. There's physical presence, means the state has the right to tax you. Economic nexus is based on revenue generation. It can be from things like the royalties from use of a patent, copyright in state, like for manufacturing, you license a patent and it's used in state, even though you yourself who hold the copyright or the patent might not have any presence in state, you may have a revenue from those licenses. Factor presence, I'll go over in a second, and Public Law 86272 will do too. So physical presence is fairly clear: real property, tangible property, warehouse, inventory, payroll. That gives you presence in state for business tax nexus. So basically with economic nexus, there's usually a bright line threshold, or often there's a bright line threshold like $500,000 in sales or royalties or license fees. Let's go to, and generally economic nexus doesn't apply to passive activities like having a bank account in state. Some activities are generally not considered doing business in state, like maintaining bank accounts, enforcing debts in courts in state, holding meetings of the board of directors. Those aren't things that are business activities. Factor presence. I'm just going to go through this by way of example. Factor presence simply means that if you have a certain amount of sales or tangible personal property, or payroll in state that exceeds thresholds, then you have Nexus and you have to start filing income tax returns in the state. Some states have these rules. California is a prime example. Public Law 86, very important. It immunizes certain taxpayers from having to pay net income taxes in the state, even if they do business in the state. In other words, even if they make sales of tangible personal property, as long as the sales are solicited and nothing more than solicitation is allowed for acceptance or rejection by a home office outside the state of the sale and delivery is made from a point outside the state of a sale, then even though technically you have Nexus, this is a federal law that restricts the state's ability to require you to file income tax returns. Key points, it only applies to tangible personal property sales, not services. And there are severe limitations on what you can do once you go beyond those things, like you go beyond solicitation, you're no longer protected. All right, here's an example. I think you can probably read this on your own as we're coming to a conclusion on this matter. But as you can see, the complexities of whether or not a business that's operating in a multi-state environment will be required to comply with the sales tax laws and the income tax laws is very significant. And there's a whole host of issues now that have just arisen because of telecommuting. Now, a lot of people are working from home, and a lot of businesses never had employees in a state where their employees are currently working. And there's a question there as to whether or not that will now be considered physical presence and whether it will generate Nexus for that business simply by having people telecommuting from other states because of COVID. These are issues we'll all have to sort through over the next months. And I want to thank everybody. It's been a pleasure speaking, and maybe we'll have time to talk later. With that said, I will go to Richard Zielinski.
Thank you, Richard. Pleasure to be here today. We are going to look at U.S. federal and international transfer pricing issues, and we're going to start here with a slide that attempts to set the foundation for corporate income tax as it was before 2018, and then as it evolved with the passage of the Tax Cuts and Jobs Act in 2017. We're going to identify very briefly some of the areas where President-elect Joe Biden has indicated he would like to make some changes. So I think without going into detail here, we can probably summarize these differences in 5 areas. First of all, the corporate income tax rate. We can't lose sight of the fact that we now have a 21% rate, which is very competitive on a global perspective, vis-a-vis the former 35% rate. We also have a quasi-territorial tax system internationally instead of the worldwide system. So that's also very much more in line with what other jurisdictions have. We have a provision called the GILTI, the Global Intangible Low Tax Income provision, which is intended to tax currently profits in low tax jurisdictions. Fourth, we have incentives to keep IP in the US, the Foreign Derived Intangible Income, FDII provision, which gives a lower rate for companies to keep their IP in the US. And lastly, we have some disincentives to outsource certain functions outside the US through, for example, the base erosion and anti-abuse tax, BEAT tax. President-elect Biden has indicated revisiting perhaps the 21% tax rate. Also, GILTI provisions would be modified. He's looking at a Made in America tax credit and also perhaps an offshore tax penalty and measures to address inversions. So that's a brief foundational look at where we are. Now, that's where the US is. Let's look at where the US is and vis-a-vis the world. Much more competitive vis-a-vis the world. So we have some jurisdictions here which are generally looked at as being very tax favorable globally, and you can see how the US compares with those jurisdictions. Now, what are companies facing today regarding changes to the global tax environment? Here you see that there are a number of different areas where they're being pressured, or they have to look at their tax planning to bring it in line with changes. So when the TCJA came out in 2017, a number of jurisdictions around the world made changes to make their rates and systems more competitive to the US. Secondly, we also have the OECD base erosion and profit shifting project, as well as the DEMPI analysis for intangibles that refers to development, enhancement, maintenance, protection, and exploitation of the intangible property. A number of jurisdictions have instituted unilateral digital sales taxes. So these are intended to address e-commerce companies which have been able to access markets, but perhaps not pay sufficient amount of tax in some tax jurisdictions' eyes. We have the EU and World Trade Organization developments with regard to, for example, state aid cases involving Apple, Starbucks, Fiat, et cetera. And then probably foremost for most of us is the COVID-19 impact and how we can help companies to address tax issues arising from that. Transfer pricing touches or implicates a wide range of issues, some which may not be front of mind. It's important to recognize these when you're evaluating transfer pricing matters, and also to think about transfer pricing when you're evaluating these other items. So if you're looking at loss planning, don't forget to think about the potential transfer pricing implications of any particular planning that you may put in place. Also on the right, we reference the OECD current project on digitization, which you may be familiar with, Pillar 1 and Pillar 2, which are looking at, again, companies that are able to access a market with a very light footprint through, for example, digital or e-commerce strategies, and also Pillar 2, which is a global minimum tax for various jurisdictions around the world. These two efforts, if they do move forward, and there are questions about that, they could have tremendous implications on the ability for tax authorities to have jurisdiction to tax, which could be very different from what we have today. Now let's look briefly at the US rules on transfer pricing. The US rules are complex. The statute is not. The statute is only 3 sentences long, Section 482, and is only 191 words. And that's expanded just in the TCJA Act of 2017. So very little is in the statute, but you have to get into the depth of it through the regulations, case law, rulings, et cetera. The arm's length standard is our foundational principle. And that basically is whether the results of the controlled transaction, are they consistent with the results that would have been recognized by uncontrolled taxpayers if they had engaged in the same transaction under the same circumstances. Now, that basically means if you have a related party transaction, you have to evaluate using different rules and methods whether the pricing in that related party transaction is the same as what unrelated parties would have agreed to. Here we have on the second bullet, a focus on risk. And we put that here because it comes up quite significantly today in the environment of COVID-19, but it's important to recognize that there are many other elements of the arm's length standard and our 482 regulations that do not deal with risk. But here we've identified a few on risk. So you really do have to evaluate the contractual terms to look at which parties bears a particular risk. And then you have to look at how that risk is allocated between the related parties, and it will be respected if it follows economic substance. So whether the parties behaved consistent with the allocation of that risk, whether the party can fund the losses that it may incur based on the risk allocation, or would a different party at arm's length suffer the consequences of such losses. And then lastly, the extent to which the party has managerial or operational control over the activity that may generate income or loss from that risk. So an example is a US parent company, if it has its UK subsidiary bear product liability risk, does that UK subsidiary actually have the ability to bear losses that may arise from that risk? What do the contractual terms say? And does the UK subsidiary have the ability to manage that risk? There are, of course, collateral issues that relate to transfer pricing generally. Here we have a few. Deductibility of ordinary and necessary business expenses under Section 162. There's a fair amount of overlap between our transfer pricing rules and Section 162, the base erosion anti-abuse tax, FDII, GILTI, et cetera. And then as referenced by Richard in the prior session, and as Zach will get into further later, a whole new level of US state transfer pricing controversy and focus. So the US rules are not the only rules that companies have to take into account. The OECD has detailed guidance, and although it's not binding legally on the US, it does very much come into play. US Treasury takes the position that the US rules are consistent with the OECD transfer pricing guidelines, and some jurisdictions around the world have the OECD transfer pricing guidelines as part of their law. So when you are looking at a cross-border transaction and the transfer pricing aspects of that, it's very important to take into account the OECD transfer pricing guidelines. These also adopt the arm's length standard, though I think some would argue that they've moved away from the arm's length standard in some respects. The second bullet here also deals with risk allocation and the detailed analytical framework in the guidelines. I won't go through those, but just note that that was a significant area of focus for the OECD 5-6 years ago when it dug into updating these guidelines as part of the BEPS project. So very important to take into account those elements. There's also an interesting discussion of what is meant by financial capacity in those guidelines. Now let's look at transfer pricing and losses. As mentioned, given where we are in the pandemic, many companies are facing losses, and if they're not facing losses on an overall basis, perhaps they have losses in particular jurisdictions. It's important to look at what are those losses. Are they arising from additional expenses because of compliance or the need to revamp their operations to be able to perform and execute in this new environment? Or are they arising because of reductions in revenue and the inability to right-size the business footprint in light of this new operating environment? And then which entities should bear the losses? Again, go back to the risk allocation provisions. So look at the agreement terms. What's the actual conduct of the parties? Look at the economic substance. Who can bear the losses? Who can fund the losses arising from the risk allocation, and who controls activities? Again, deductibility of losses and expenses under 162 and the case law will be very, very important, as well as these other provisions that are indicated here. There's quite a lot of experience in addressing supply chain loss challenges around the world. So for example, if you shut down a plant in a particular jurisdiction, how do we handle the allocation of the costs that come from that? And most importantly, not all companies are adversely affected by the pandemic. Some e-commerce, online, et cetera, are actually doing very well. For them, the question is, how do they address unanticipated profits or upside gains from the pandemic? Who should bear, or who should have the ability to keep or earn those unanticipated profits? Now let's take a look at a case study. This is relatively simple. So this is an inbound case, inbound to the US. We have basically the USD, US distributor, purchasing products from its foreign parent related company and selling those products on to unrelated customers in the US. If we are looking at a COVID-19 situation and potential losses, it's important to look at what's giving rise to those losses as mentioned. If, however, this is a market share strategy, so for perhaps the US distributor is intending to increase its market share in the US, it may be incurring certain expenses as part of that and will be looking at potentially lower returns or maybe losses over some period of time with the objective of recouping them down the road. How would we evaluate the transfer pricing issues? Again, we look at the intercompany agreements, we look at the risk allocation. It's also very important to think about any internal comparable uncontrolled price or comparable uncontrolled transactions. So if FPCO sells the same or similar product to an unrelated party in the US, that might provide extremely reliable evidence of arm's length pricing. Or if the US distributor buys the same or similar product from an unrelated party, that also could be a cup or a cut. If, however, we don't have any of those internal data sources and we're looking at more of a profits-based method like a CPM or TNMM, what should we be doing to reflect these unusual circumstances that we're in right now? So is there any internal data at the US distributor that would allow us to identify the impact of COVID-19? Or are there particular comparables or market data that allows us to evaluate the arm's length return for that US distributor? And then finally, is there an advanced pricing agreement in place or being negotiated? We'll get into these a little bit later, but they can be extremely helpful in terms of providing certainty and negotiating upfront with the IRS and other tax authorities as to the transfer pricing implications. Now, the next case study is also inbound to the US, but this has a much more fulsome, more complex US company that's performing full-scale R&D, full-scale manufacturing and distribution operations. It has significant intangible property that it owns in the US. And here we're looking at a situation which would arguably, in many cases, say we should be looking at the entire system profit. So for example, the profit at FPCO and also the profit at USCO, perhaps applying a profit split methodology if we have non-routine contributions at both the foreign parent company and the US company. And this is complex, but we have a lot of experience in using these types of methods in different forums, whether it's advanced pricing agreements or in controversy otherwise. Similar type of situation arising with regard to how to evaluate this, looking at the intercompany agreements, the risk allocation. Is there an APA? How is a foreign parent company faring in terms of profit and losses, et cetera? Now, the flip side is the next case study, and this is a US outbound case. So a US parent company with relatively complex operations outside the US. We have IP owning activities with entrepreneurial functions and high profit potential functions in the regional headquarters principal and also the IPCO. But then we have relatively low risk or contract type operations in the R&D company, the manufacturing, and the risk distribution, limited risk distribution operations. If we do have losses in this situation at the low risk type of entities, how should we be looking at those from a transfer pricing perspective? You might say that if it's limited risk or contract, it shouldn't incur any loss. But data actually suggests that there are situations where limited risk or contract type of operations may incur a loss. It depends on the facts, it depends on the intercompany agreements, and it's an exercise that you can apply to many different situations. The next slide Now, we won't go through this, but just wanted to highlight BEAT. So there is a significant overlap between the BEAT and transfer pricing. There are a number of planning approaches that are important to keep in mind. If you are a large company, so if you have more than 500 million of revenue over the prior 3 years, and if you have a certain level of base erosion payments outside the US, so payments made to foreign related parties by your US operations, the BEAT may apply to you. And here is a list of the different types of planning approaches that we've been looking at to help a significant number of companies try to address and minimize BEAT exposure in this type of environment. The most important thing here to note is your pricing can be completely arm's length and acceptable from a transfer pricing perspective, but that does not eliminate the potential BEAT exposure. BEAT doesn't care whether your payments are arm's length. It only cares about the magnitude of the payments. Now let's switch gears to the next topic, which is resolving transfer pricing disputes. There is continued transfer pricing enforcement by the IRS through campaigns, examinations, litigation. The Coca-Cola case was just announced November. The opinion there at the tax court came out November 18th. Very significant victory for the IRS in that case. About $3.3 billion of tax deficiency involved. Enforcement is definitely something that companies have to keep in mind. But there are different mechanisms to resolve the disputes. These depend upon whether the dispute arises from the US IRS, so is it an IRS adjustment, or is it a foreign initiated adjustment from CRA in Canada, or the UK HMR, et cetera. There are practical issues in resolving these transfer pricing issues. There can be a desire for a quick resolution versus a principled resolution. Local examiners in some jurisdictions tend to apply significant pressure to companies to resolve the issue without going to the mutual agreement procedure, which can raise difficult issues in terms of preserving the ability to request relief from double taxation. And there are a number of other points here, but just note that it's important to be very aware of what these options are to resolve transfer pricing disputes. A quick snapshot of the US APA developments. So in the US, we have the IRS Advanced Pricing and Mutual Agreement Program, referred to as APMA as short. These are a form of alternative dispute resolution. Here are some stats just to give some context. They are overburdened, so they have a significant backload. It does take a significant amount of time to receive an APA. It can take, on average, about 38 months. You can see the countries with which the IRS has significant experience: Japan, Canada, Korea, Australia, and many of the European jurisdictions. And you can see a little bit there about the organization. Now, we also have data on MAP development. So these are cases which may not be APAs. So they would be a case where you have an adjustment that arises in the US from an examination, and then that case goes up to the competent authority process to be resolved by the IRS and another tax treaty jurisdiction, for example, Canada. We have here statistics showing that there is a large increase in the MAP developments. These are global numbers. So these show that the inventory has increased between started cases, and the closed cases have not been able to keep up with the started cases. One positive element here, the timeline to resolve cases has decreased, and relief from double tax is provided in more than 70% of the cases. Here shows some data on US MAP statistics. I'll let you look at that on your own, but just note that approximately 90% or more of the MAP cases in the US are resolved favorably with complete or partial relief from double taxation. And the final slide, some best practices. So prepare to adapt your structure in light of US and global tax changes. Recognize the interaction between transfer pricing and other tax provisions. develop and put in place your plan to address COVID-19 impact from a tax perspective, and know your options so that if a dispute does arise, you can resolve it in the most effective way for you. Thank you. I'll turn it over to Zach.
Hi, good morning, everyone. My name is Zach Lavie. I'm in the New York office of Alston and Bird, and we are going to now take what Richard Goldstein and Richard Selinsky have gone through and shift back and circle back to state and local tax issues, focusing now on transfer pricing developments. We're going to first touch base on some background and what the states sort of use to introduce transfer pricing into their rules. We're going to secondly look at key cases and developments from around the states. And then we're going to talk finally about best practices. Let's see. There we go. All right. So the statutory regimes, how states incorporate federal 482 rules, and what Richard just went through in a lot of cases is important to consider and impacts sort of positions and controversy from around the states, as we'll see from some of our case law examples. A number of states expressly adopt Section 482 and oftentimes expressly adopt the 482 regulations they're under from the federal level. An example of this is North Carolina, that specifically says North Carolina looks to Section 482 and its regulations thereunder for purposes of determining what arm's length pricing is. Other states use substantially similar authority. The arm's length standard, for example, they're incorporated directly into the state statute, but they may not reference 482 directly. And that's where we'll see a lot of our state tax controversy come from, in terms of the issue litigated as to whether 482 and its regulations for what is arm's length pricing, whether it's determinative for state tax purposes. And then other states, finally, sort of the third bucket, is where states provide a general authority to adjust. And usually these are discretionary statutes, oftentimes, that allow the Department of Revenue's discretion to make adjustments, force combination, use add backs or other adjustments, apportionment if necessary, to reflect what is often called something like true earnings to the state. And that is, for example, prior to 2012, North Carolina had a statute referencing true earnings and allowing the Commissioner of Revenue in North Carolina to make any adjustments necessary to reflect true earnings in the state. And that's where your Walmart and Del Hayes cases came from, under that old rule that gave broad authority to force combination. And you saw that in a number of states. Nearly every state has some statutory framework to adjust transfer prices. I mentioned add backs. Those were very popular and often used. But some states don't have any statutory authority. We have some examples here: Delaware, New Mexico, and Pennsylvania. And in some of those states, Pennsylvania, for example, the state will rely more on case law dealing with sham transaction doctrines, step transactions, really going to the business purpose and economic substance of the intercompany transactions. They'll often look to federal law for those issues. So even states without statutory authority oftentimes are able to assert similar positions than the states that have 482 statutes. So now we'll get into some key cases. The first state we have here is Utah, and this is an important case. And I'll pause here just to mention, in these state tax cases, when you look at them and study them, thinking about them deeply, you really come to see a very important undertone in them, and often a first step to really get to transfer pricing, and that is establishing a valid business purpose and economic substance. And I think oftentimes if you overlook that element and dive directly into transfer pricing and whether the transactions are at arm's length for state tax purposes, you may have done yourself a disservice, because really that's a key component for state taxation is establishing to an administrative law judge or somebody else that may not be a tax judge that the intercompany transactions that were put in place, the structure was put in place for valid business purposes. And then it's not just a state tax play. And that's really an important part. I think when we discuss this issue internally, when we're litigating these issues, we often say that if you're able to affirmatively establish business purpose and economic substance and show valid reasons for the structure, why it's put in place, why it's beneficial to the company, then you are more than 50% there in terms of establishing why the intercompany transactions should be respected. And then the next step of that analysis obviously being whether they're at arm's length pricing, which is really where then you get into the transfer pricing reports, if there are official reports that are contemporaneous, and you get into expert testimony, of course, there too. In Utah, you have the Utah State Tax Commission versus See's Candies. See's is a wholly owned subsidiary of Berkshire Hathaway, and it moved its intellectual property to another wholly owned affiliate of Berkshire Hathaway, the Columbia Insurance Company, in exchange for stock. And then they created intercompany royalty for use of that intellectual property that was paid to Columbia Insurance Company. Columbia was responsible for the insurance premiums tax in Utah, which is much lower rate. And I think key to all this, and See's Candies had a lot of success. This case started with the tax commission and went all the way up to the Supreme Court. It's a relatively recent case and has very good analysis. The taxpayer here hired 3 experts who did an excellent job of first establishing business purpose, and then secondarily getting into transfer pricing and proving that these transactions were at arm's length. And what Utah tried to do, you'll see this throughout the case law, is the statute here, section 59-7-113, was virtually identical to section 482. And Utah tried to, in many ways, disavow a requirement to look to 482 or its regulations for what arm's length pricing was. And really, I think the undertone again here was that this transaction, the movement of the intellectual property to the insurance company, didn't have sufficient economic substance and business purpose. I think they were really trying to establish that for Utah purposes, this was a state tax play. And they were able to, See's Candies was able to successfully prove that they had economic substance and business purpose. And then getting into 482, the judge found that 482, even though not directly referenced, it was clearly looked to by the Utah legislature, and that it should be treated as persuasive authority, which was really all See's Candy needed to prevail on the matter and establish through valid transfer pricing reports that the transactions were at arm's length. I think there was a 10% adjustment to the intellectual property based on comparables in the case. But ultimately, it was a great taxpayer victory, many of which you see from around the nation in states, if you can prove economic substance and business purpose, especially where the states track Section 482 statute and regulations. Secondly, we'll get into DC. Here you have what is really referred to as chain bridge litigation. You have Hess Corp's case here that they litigated in conjunction with Exxon and Dutch Royal Shell And these cases followed an important Microsoft case that we'll mention in a moment. But Chambridge Software LLC was an outside contractor that the Office of Tax and Revenue in DC hired to conduct transfer pricing audits and look at companies and come up with assessments essentially. And as you'll see, Chambridge it was argued that they violated Section 482 because the study didn't make any distinction between controlled or uncontrolled transactions, and therefore they failed to apply the comparable profits method in an appropriate manner. In Microsoft, a case that preceded these cases, the ALJ there ruled that the transfer pricing reports, the studies conducted by Chambridge, where they violated federal transfer pricing guidelines, and that the method they used was useless in determining whether Microsoft's controlled transactions were conducted in accordance with the arm's length standard. So really, Chambridge did not fare well in the Microsoft litigation, and its study was really sort of torn apart by the administrative law judge. Ultimately, Hess and the other oil companies moved with a motion for summary judgment on the basis of estoppel, arguing that the Office of Tax and Revenue was stopped from making the same arguments again, and that summary judgment motion was overruled, and the different administrative law judge held that there were issues of fact that needed to be addressed. So next, we're going to mention a couple of Indiana cases. Similar to what we've seen in Utah, Indiana had a statute that tracks but does not directly reference Section 482. And ultimately here, Indiana and Columbia Sportswear and an affiliated case, well, it's a case that came out the same year as Columbia. It was not affiliated, but the Department of Revenue in Indiana took a similar position and tried to, again, disavow federal 482 principles and arguing that it had discretion to make adjustments. And again, the undertone here in the Indiana cases was that these were transactions set up for state tax advantages and that they should not be upheld. And here you see a reference to Rent-A-Center. In both cases, the tax court in Indiana looked to Section 482, said that it was highly relevant, and that the taxpayers had established through transfer pricing studies that their intercompany transactions were at arm's length rates. Then you have a letter of findings, which is an administrative determination within the Department of Revenue on appeal from an audit conclusion. And you have the Department of Revenue acknowledging that based on Rent-A-Center and Columbia Sportswear, that they did not have authority to disavow Section 482, and that the audit didn't sufficiently address with specificity the shortcomings of the transfer pricing study. So basically acknowledging that in Indiana, you really had to affirmatively establish why it was that transfer pricing was improper. Here we have a New York City tax tribunal decision from the administrative law judge level. And this year, an issue in this litigation, you had substantial intercorporate transactions in New York, where if you had substantial intercorporate transactions, distortion was assumed. And the only way to rebut that presumption was to prove through Section 482 that the transactions were at arm's length. Here, this investment firm did not have a contemporaneous transfer pricing study. They had an expert perform one, and the administrative law judge went through a number of deficiencies that they found in the transfer pricing report. So a couple of, we have a couple of minutes here to conclude important developments from around the states. You're seeing a shift now where states are moving away from forced combination and drastic add backs and and they're moving a little bit closer to what you've seen at the federal level for some time now in terms of negotiating what proper transfer pricing is, negotiating what the comparables could be. North Carolina has had a transfer pricing resolution initiative. It is closed now. It's in the final stages of negotiations. They're trying to wrap those up by year end. We had 2 clients go through the program and had very good experiences. The department being very reasonable through this program and often didn't make any transfer pricing adjustments or minor ones. Had a couple of issues come up where the procurement company was asserted by the department to have Nexus with the state. And they had unusual facts that led to that conclusion, but we were able to negotiate on sort of apportionment for the procurement company and reach a good resolution. Indiana has a similar program, and it's more tailored after the federal advanced pricing agreements. It's intended primarily for certainty for go-forward periods, but they've also said they're open to resolving ongoing disputes, and it's intended to apply resolution for 2 audit cycles or 6 years. Best practices here, of course, regularly update your transfer pricing studies. We often see from clients, at least 3-year intervals. Review your intercompany agreements. Make sure that they align with your facts. We note here use different signatories for each party to the agreement. Oftentimes you see overlapping officers, so I don't think it shouldn't be essential to upholding business purpose, and that's really the issue that it goes to. And finally, here we note that the actual facts need to reflect the internal structure and what those intercompany agreements are, because if there's a failure and the facts as they truly exist as compared to how they're documented, obviously the state's going to sort that out through discovery and potentially depositions, and discovery can be onerous in state tax litigation on transfer pricing, and you can really undermine your economic substance and business purpose. And on that point, it's important for board minutes and presentations to the board not to only focus on state tax benefits from intercompany restructurings, but also focus on all the other business purposes. Tax can be an integral purpose behind a restructuring. It just can't be the only purpose for business purpose to be upheld. With there, I'll stop and turn it over. I went a couple of minutes over here.
Thanks, Zach. It seems that we are at 11, a little bit past 11, and it seems that we've run out of time today for any Q&A, but please note that any questions that have come through will be shared with our presenters who follow up with you individually. On behalf of Bird and LLP and Alton and Bird, I would like to thank our speakers for providing such an informative program. Thank you, and also a big thanks to you for all attending this morning. Enjoy the rest of your day.
Thank you.
Thank you.
Thanks.